Well, we will not be napping during the after lunch. All right, let's bring up Charles Stimpson from the Heritage Foundation.
Mr. Chairman, I want to thank you for the privilege of coming out here to Michigan, where my family has deep roots, as I talked about in my written statement, and also for the chance of getting out of Washington, and for the unenviable position of being the last witness before the lunch break.
We're not sure about that yet, so
I'll speed it up.
maybe you might not be, depending on your speed.
Right. My name's Cully Stimpson. I'm a senior legal fellow at the Heritage Foundation. I am the co-author of this book, Adult Time for Adult Crimes. I've sent 10 copies out here to you all, and it's also downloadable free off the internet, and I can send more copies to the committee or their staff if you'd like them. I'm not here, well, as a way of background, like Representative Robinson, I've had the privilege of being a defense attorney. I've represented child abusers and others accused of horrible crimes. I've also had the privilege of being a local, state, and federal homicide prosecutor in the District of Columbia. And I now currently serve as a military judge in the Navy Reserve. I'm not testifying in any of those capacities. I'm testifying as a legal scholar from Heritage and as the author of this book. And I'm not here to support or defend or oppose any of the legislation. I can't do that as a person who works for a 501c3 tax-exempt organization. I take no position, nor does our organization take a position. I'm here to provide more of a national perspective on the movement, either supporting life without parole and then those opposed to life without parole. This is a tough topic. And in our book, which we wrote right before the Graham and Sullivan cases before the Supreme Court a few years ago, we wanted to do deep research and really ask people in all the states, 43 states at the time, the District of Columbia and the federal government had life without parole for juvenile killers and violent teens at the time. You know, what are these cases really about? What are these crimes involved? Who are the victims? Who are the defendants? And so we've narrowed that class of individuals down to 16 case digests. You can see that your state is not the only state that has juvenile teen killers. We highlight the facts from court records from many states. But I will say this, what our research shows is not surprising, but I think it should certainly be repeated here at this hearing. Most juvenile offenders should not and do not go into the adult court. Most juvenile offenders in all the states, and all 50 states have juvenile justice systems, properly go through the juvenile justice system. Whether it's good or bad is not for this hearing, but they have a juvenile justice system, including murderers and rapists and other horrible crimes. That is the way it should be. That is a part of the winnowing process as we get closer and closer to that narrow class of individuals who get waived to adult court or automatically go to adult court depending on the state scheme that the legislators passed. Some states, for example, say that if you are charged with first-degree felony murder or first-degree murder, you automatically, regardless of your age, go to adult court. Others have cutoffs. Texas, for example, says 16 and below aren't eligible for LWOP, period. Today, and I want to correct one thing I wrote in my written testimony, there's 40 states that authorized juvenile LWOP. It's not 43, it's down to 40, I believe. The District of Columbia and the federal government offers it. But it's very clear, because we worked with the state of Florida in the Graham and Sullivan cases and coordinated all the amicus supporting the sentence. It's very clear because we worked with the state of Alabama in the Miller v. Alabama decision and coordinated those amicus, that the majority of states, as the SG said, have this as the ultimate punishment for a very, very narrow class of individuals. What you as legislators are doing is the right thing. You're deciding where's the line. We know on the law side, the line is that the sentence is constitutional. Graham and Sullivan certainly said that, and the Miller decision certainly says that. Miller simply says it can't be mandatory. That's the Miller decision, and the SG, whose testimony was outstanding, I would incorporate by reference, and I would also incorporate by reference a lot of Professor Thomas's comments, and I just want to pick up a couple of things that she said and put a little more finer gloss on it. I also want to point out that when the SG talked about how Miller not being retroactive, he's exactly right. And I don't believe the Supreme Court has an appetite anymore to take up the constitutionality question, because they know, as these victims' families and the offenders' supporters know, that some of these crimes are horrible. They're not defensible. The question is whether the state sentencing scheme should allow for some ability to be rehabilitated later in life. That's something you all have to decide. That's a tough decision, and I'm not going to weigh in on that one way or the other. Sir Representative McBroom asked the question of how many states. I think I've answered that. It's now 40 states, the District of Columbia, and the federal government. Professor Thomas touched on a couple things that I want to talk about. And by the way, in the book, we lay out all the states that have it, the state statutes that have it, the arguments that the other side have made over the years, like it's a violation of international law, which it's certainly not. It's not a violation of international treaties. It's certainly not. And I lay out the conundrum of the statistics because even you all don't know the exact number, and a lot of states don't collect the statistics well. That may be one thing you want to consider doing in your legislation, figuring out how you actually get the metrics on this number of individuals going forward. There's three classes of individuals here. And I want to try to break it down because this goes to Representative Graves' question, really. There's the class of individuals in jail right now in Michigan, and have been for some time, whose cases are final. The Miller decision does not affect them. There's the class of individuals whose cases were pending or on some sort of review, and that is affected by the Miller decision. And there's the cases that are going to happen tomorrow and next week and a month from now and years later where the Miller decision clearly applies going forward. Two other points from Professor Thomas's testimony that I just want to touch on, Mr. Chairman, and then I'll stop for your questions and those of your distinguished members and colleagues. She stated that 39 states treat 17-year-olds as juveniles. True. All states, all 50 states, the District of Columbia and the federal government have the ability to waive juveniles from juvenile court to adult court for certain classes of crimes. Some states do it by saying, okay, if you commit X crime, you're automatically in adult court. Other states say it's a certain cutoff. If you're 16 and above, you automatically go to adult court, and they do it by crime. The vast, 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 vast majority of these people serving JLWOP in the states are 16 and 17-year-olds. And the advocates who have published some reports over the years, actually, when they did their methodology in terms of accounting for these numbers, they always repeat the number of 2,225 of these people around the country. Well, there's really no way of knowing the number, because in their best guess, they include 18 and 19-year-olds. So there's really no way of knowing the exact number. But in your state, it's somewhere in 300 range. Another point that Professor Thomas said, she correctly pointed out that Texas, Wyoming, and Colorado eliminated JLWOP as a sentence. They did, and they substituted very, very, very long sentences for people convicted of very serious crimes. And they provide a meaningful opportunity for review of those sentences, either by the judge or later by the parole board or both. So I'm going to sit back and simply say that I don't envy your task. I wish you the best of luck in making these decisions. Clearly, you have to do something in your state and provide guidance to the distinguished men and women who wear the black robes, who make, who do justice in their courtrooms. How you do that is up to you. I don't think the court, as the Solicitor General said, is going to find that Miller is to be applied retroactively at all. It's not a substantive rule, it's a process rule. Thank you, Mr. Chairman.
Any questions? Representative Vice Chair Graves.
Thank you, Mr. Chair. Sir, thank you for your service to our country as a member of JAG. I would like to, you just touched on it. I know we have different classifications. I actually have a different classification, in my understanding. But we have to make a decision to do something different. We can't continue doing what we're doing.
Well, I think to the SG's point, you could. You could sit back and do nothing, and then the results would be as he testified to. I think the bills before you, although I haven't studied them in depth, would give guidance to the judges with respect to what they need to do. But as I understand it, if you're a juvenile today and you're waived to adult court and you're convicted of first-degree murder, and the judge holds a Miller-type hearing and looks at the various things that Professor Thomas talked about, and she finds, the judge fill in the blank, whatever her name is, finds that there are mitigating circumstances, something that the doctor talked about, the brain development, that would be great, but they're still getting LWOP. And so to come into compliance with Miller, you need to do something.
We recently had a case tried in Flint where a individual was tried under those circumstances. The judge asked all the right questions moving forward, and he was given life without parole because he met all the requirements. My confusion is why, if it's unconstitutional to go forward, why wouldn't it be unconstitutional not to be retroactive?
Well, and I'll again associate myself with the SG's comments, but the dividing line is it a decision? Is this decision, does it categorically ban a certain type of sentence? In other words, in the Roper against Simmons decision, the Supreme Court said that the death penalty is unavailable to juveniles. And so any juveniles then serving on death row, who are anybody who's a juvenile serving on death row, those cases, those death sentences are thrown out. Here what they're saying, and again I'll quote from the decision, the court expressly stated that the ruling, quote, mandates only that a sentence follow a certain process. That's the legal term of art, the buzzword.
Correct.
So all the lawyers get all tingly in their ears because they see the right buzzword. Considering an offender's youth and attendant characteristics before imposing a particular penalty. So that is a procedural rule on cases that were pending and cases going forward starting tomorrow and whenever, any on the day of the decision going forward. And the decision came down in June 2012. So you don't have to go backwards and redo that. Now, as a matter of policy, if you all can convince enough of you such that a majority of you do that and it doesn't get vetoed by the governor, that's your prerogative. And you can do that as a matter of as a matter of legislative grace, and as a matter of fairness, because there was some question earlier about fairness. If you think that's the fair thing to do, considering the victim's testimony coming later today, and considering all the equities that you all have to look at, you go right ahead and do it.
Okay. Thank you, sir.
Any other questions from House members? Rep. Robinson, did you have a question?
I was going to make a comment.
No.
For a moment there, I thought you were going to lose your tax exemption when you were adopting the SG, but then I see you balanced it out in the last response.
Thanks for the hall pass. Appreciate it. Thank you, Mr. Chairman.
Thank you very much.
Yep.
We have about 10 minutes before the noon hour. Is Judge Mester still here? Yeah, but I'd rather wait until after. You're going to wait until after? Okay.